Iginiit ni NBI Director Jaime Santiago na dumaan sa tama at legal na proseso ang pag-aresto ng dating Pangulong Rodrigo Roa Duterte. Hindi daw makakatulong ang pagsagawa ng people power ng mga kaalyado nito. Pero kayo ang tatanungin ko, tama ba ang proseso sa pag-aresto ni Pangulong Rodrigo Roa Duterte?
They have all the remedies. Our Supreme Court, our judicial system is functioning. They have all the remedies. Gawin nila yan. Pero wag nang magtatawag ng people power, people power. Hindi malulutas ang problema sa marahas na pamamaraan.
So nasa tamang proseso?
Sa akin, nasa tamang proseso.
Pero kung ako ang tatanungin nyo, under the role of Rome Statute, Article 59, meron talaga silang nilabag na batas o mali ang proseso sa pag-aresto sa dating Pangulo. Dahil hindi ako gaanong magaling sa pag-interpret ng batas at sa proseso sa pag-aresto ng isang may arrest warrant under International Criminal Court, meron akong kaibigan na magpapaliwanag sa inyo. Please help me welcome, Attorney Neil Abayon.
So ang pinakatitingnan po natin today is none other but still the Rome Statute pa rin po. Specifically, Article 59 po ng Rome Statute. So may kita po kasi natin dito, Article 59, nakalagay po dyan, arrest proceedings in the custodial state. Okay, so ano po ba ang procedure according sa Rome Statute? When a person is arrested, he shall be brought promptly before the competent judicial authority. Okay, so take note po a person pag inaresto, dapat siyang dalhin agad sa competent judicial authority. Ngayon ang next question, anong competent judicial authority yung kailangan dalhin yung taong isang arestado? Nakalagay din po yan dito which states here in the custodial state. Okay? Ang ibig sabihin po ng custodial state, yan po yung bansa kung sino yung may custody nung akusado. Okay? Tapos ang next pong gagawin dyan, yung competent judicial authority shall now determine in accordance with the law of that state, kung unang-una, letter A, whether or not the warrant applies to that person. Okay? Pangalawa, letter B, whether the person has been arrested in accordance with the proper process. Okay? And letter C, whether or not the person's rights have been respected. Okay? So makita po natin, Article 59 of the Rome Statute is very clear po. When a person is arrested, dapat agad siya promptly dalhin sa competent judicial authority of the custodial state. Tapos yung competent judicial authority na yon or yung mga courts po has to determine kung nasunod ba yung A, B, and C na binanggit ko. Okay? So ngayon, ang next po natin kailangan tingnan is ano ba ang nangyari sa pag-arrest or yung proseso ng pag-arrest kay FPRRD. Okay? So bago po tayo pumunta dun sa A, B, and C, yung una po talaga natin kailangan i-determine is whether or not FPRRD was brought promptly to competent judicial authority of the custodial state. So I'm assuming, alam nyo naman po siguro yung sagot, di ba? Ang dami naman pong videos lumalabas kung ano yung procedure nangyari. Pero anyway, briefly i-discuss ko kung ano yung personal observations ko po based on all the videos I've seen and all the news articles I've read yesterday. So nangyari po sa FPRRD, he arrived from Hong Kong. Tapos pagdating po niya sa Hong Kong, ano ginawa? Kinuli agad siya dun pa lang sa airport. Tapos diretso dinala siya sa Villamor Air Base. So ang question dyan, is the Villamor Air Base a competent judicial authority? Okay?
No.
So that is very self-explanatory. I'm sure a reasonable person would be able to answer that himself.
Yes.
Okay? So dun pa lang po makita natin, FPRRD was not brought before a competent judicial authority. So from the very foundation of this requirement po, medyo may problema na agad, okay? Pero anyway, i-discuss pa rin natin yung A, B, and C kung meron bang lapses din doon. So sa letter A, based doon sa pinakitang warrant of arrest ni General Torre, nakapangalan naman doon, Rodrigo Roa Duterte, so it appears that the warrant applies to FPRRD. Ngayon, yung next dito is whether or not the person has been arrested in accordance with the proper process. Okay? So one of the most common questions po na nakikita ko dito is kung pwede ba daw yung soft copy lang na warrant of arrest. So sa rules of procedure po natin, sa rules of criminal procedure po natin, nakalagay naman dyan na hindi naman kailangan talaga na physically hawak-hawak talaga ng arresting officer yung warrant pag-aresto. Ang required lang po dyan is pag humingi po ng kopya yung akusado, dapat within a reasonable time mabigyan siya nung copy. Okay, so doon po medyo tama naman yung ginawa nila General Torre na kahit soft copy lang yung ginamit pag-serve sa kanya. However, General Torre has to be reminded of the second portion which is that dapat pag humingi po yung akusado, within a reasonable time mabigyan po siya ng kopya ng warrant. So ngayon, di ko po alam kung nabigyan ba si FPRRD within a reasonable time ng kopya because medyo magulo pa po lahat ng actual happenings in the process po ng arrest. Okay? So yung next question naman po natin dito, whether or not the person's rights have been respected. So ito po medyo magulo pa din yung facts talaga. May nababasa ako na at the time of arrest, wala daw pong abogado sa FPRRD. So one of the rights po kasi of a person who is being arrested is that he must have a lawyer present of his choice. So kung totoong wala talaga siyang abogado, di dun po posibleng nagkaroon na ng lapses. Okay? Yung pinaka-clear na nakita ko pong isang lapse is yung sinasabi ni FPRRD or nire-request po niya na naantayin daw si Vice President Sara Duterte dumating. Tapos sabi niya, my daughter is my lawyer. Pero sabi ni General Torre is that hindi daw pwede na maantay. So dun pa lang makita din po natin that can be considered as a lapse since hindi po inalaw yung akusado dito na antayin yung counsel of his his choice, which is his daughter, Vice President Sara Duterte. Okay, however, this situation po can be countered considering nandun naman si former Executive Secretary Medialdia, and I believe Attorney Martin Delgra was also there. So pwede yun i-argue nila General Torre na may counsel naman na si FPRRD. Pero yung counter-argument nga dun FPRRD is yung counsel of choice niya is si Vice President Sara Duterte. So dapat inantay. So these are all arguments lang po, gray areas pa lang po to. Hindi talaga natin sure kung sino papanigan ng korte. Pero overall po, kung ako tatanungin yung professional assessment ko po talaga sa situation, the mere fact that the accused FPRRD was not brought promptly before a competent judicial authority, that is already a clear lapse or mistake po under Article 59 of the Rome Statute. Okay? So dito po nakalagay is that the person arrested shall have the right to apply to the competent authority in the custodial state for interim release pending surrender. Okay? So yung surrender po dito, hindi po to surrender ni FPRRD sa police force natin. This is surrender of the accused to the International Criminal Court. Yan po yung surrender dito. Ito pong number 3, ang pinaka main point po dito, pag yung isa pong akusado sa ICC case na aresto na ng custodial state, meron po siyang right to apply to the competent authority for an interim release. So ito pong interim release, this is more or less similar po to the right to bail. So makikita po natin, di ba, sa number 3, meron din pong right to apply ng interim release ang isang akusado. So dito po, again, this can already be considered a violation since yun nga, si FPRRD was not brought promptly before a competent judicial authority. Second, he was not also given the right to apply for interim release pending surrender. Take note po, number 3 specifically states the person arrested shall have the right to apply interim release pending surrender. So in short, the word shall means mandatory po yan na may karapatan talaga siya mag-apply ng interim release prior to his surrender dun po sa ICC. Okay? Ngayon punta naman po tayo sa number 4. Okay? This is still Article 59 pa rin po lahat to. Okay? So Article 4 nakalagay po dito, in reaching a decision on any such application, yung application po na to is the right to apply for interim release. The competent authority in the custodial state shall consider unang-una po yung gravity of the alleged crimes. Pangalawa po, urgent and exceptional circumstances to justify interim release. So dito po, ano po ba yung gravity of the alleged crimes? Of course, seryoso po because ang allegations po against FPRRD is crimes against humanity. So yung gravity po ng offense alleged against FPRRD shall be considered po in relation to the urgent and exceptional circumstances considering po the status of FPRRD. So isa pong pwede gamitin dito ang argument ni FPRRD is of course his age because he's already 80 years old. So doon na lang po yan, pwede yan timbangin kung whether or not yung age niya being 80 years old can be considered as a valid justification po for an interim release. Okay, so again, that is up to the competent judicial authority or the competent authority in the custodial state to determine kung mas matimbang ba yung pagiging 80 years old na ni FPRRD in relation to the crime alleged. And lastly po, number 7 dito nakalagay, once ordered to be surrendered by the custodial state, the person shall be delivered to the court as soon as possible. Okay, so yung court na tinutukoy po dito, hindi na to yung regular courts natin dito sa bansa natin, sa Pilipinas. This is already the ICC yung tinutukoy. So ang kailangan po, merong order from the custodial state na iso-surrender na. Therefore, kung makita po natin, it must undergo all these processes, yung mga diniscuss ko po ngayon, para po makagawa ng proper order for surrender yung custodial state dun sa ICC. Okay, so overall po, yung assessment ko po in the implementation ng warrant of arrest against FPRRD, meron pong mga lapses talaga. Kung ako po tatanungin, that is my professional assessment and or observation. Okay, you are free to disagree with me, pero kung ganun po, wag na po kayo makipagdebate kasi wala naman pong mananalo sa atin sa comment section. Okay? Because again, tandaan po ninyo, I am a licensed lawyer who is interpreting this provision in accordance po with my knowledge and wisdom, of course, as a lawyer. So again, yung professional assessment ko po is meron pong lapses as required by Article 59 of the Rome Statute. So again, ulitin ko lang po, yung una pong lapse na nakita ko dito is yung failure to bring FPRRD promptly to competent judicial authority dito po sa bansa natin. Okay? At yung rason po niyan is para makita po talaga at para matingnan ng korte natin kung meron bang violations or lapses sa pag-serve ng warrant of arrest or kung meron po bang violations against constitutionally protected rights natin such as that of the right to due process. Okay? So yan po yan. And then yung next din pong violation nakita ko dito since nakalagay sa number 3, the person arrested shall have the right to apply to the competent authority for interim release. Yun din po, hindi na po nabigyan si FPRRD ng right niya na yun to apply for interim release. Ang nangyari po, dire-diretso siya from the airplane to Villamor Air Base to another private airplane. So yun po yung mga violations na nakita ko dito sa pag-serve po ng ICC warrant of arrest against FPRRD. Overall po, kung titingnan natin lahat ng diniscuss ko dito, makikita po natin na yung essence po ng arrest proceeding as required by the Rome Statute is hindi po siya dapat minamadali. Diba? Kasi kung makikita po natin, yun nga, unang-una, kailangan padalhin sa korte, tapos yung korte, kailangan padesisyonan kung talagang tama ba yung warrant of arrest. Yung unang, letter A, kung nakapangalan ba sa warrant of arrest is yun talaga yung inaresto. Pangalawa, kung nasunod yung proper process. At pangatlo, kung nasunod ba yung mga karapatan or narespeto ba yung mga karapatan nung akusado. Tapos number 3 po, nakalagay din, meron pang right to apply din for interim release yung akusado. So all in all po, considering these matters na kailangan i-discuss ng competent judicial authority in the custodial state, this would indicate na hindi po siya bagay na minamadali lang. And most likely the reason kung bakit ganito po yung requirement ng Rome Statute natin, kasi kung babasahin niyo po yung ibang provisions dito sa Rome Statute, diba, ina-emphasize din po nila na they respect and follow the right to due process. And the right to due process is ganito po yan. Ganito po yung proper procedure if the right to due process was actually followed talaga in relation sa pag-implement ng arrest warrant, ng ICC arrest warrant against FPRRD dito po sa bansa natin, which is the custodial state po regarding this case. Okay? So klaruhin ko lang po hindi ko po sinasabi na hindi kaya gawin lahat to in one day. Yung point ko lang po, hindi to siya dapat minamadali yung pag-surrender po ng isang akusado sa ICC court, okay? So again, ulitin ko, I did not say na hindi po to pwede gawin in one day. As long as makomply po to lahat, magawa ng one day, di wala po sanang problema. Kaso yung problema po dito sa case ni FPRRD, hindi po lahat nangyari to eh. Wala pong surrender or wala pong bringing promptly to competent judicial authority. Ang nangyari po, dire-diretso, airport, Villamor, airplane, and then lipad. So doon po makikita natin na meron ng mga possible arguments and or defenses po si FPRRD regarding po the enforcement or the implementation of the warrant of arrest against his person. Okay?
O di ba ang dami nating natutunan? Sana ay nalimunagan kayo sa proseso sa pag-aresto kay Pangulong Digong at sana maliwanagan din si NBI Director Jaime Santiago tungkol dito. Hindi lang si NBI Director kundi kasama na din si General Torre, PNP spokesperson Fajardo at iba pang mga matataas na opisyal na involved sa pag-aresto ng dating Pangulo. So dito lang muna tayo mga kaibigan at see you in my next video. Maraming salamat po.